Thank you. If you could please have a seat in that chair.
Sure, it doesn't move.
It does move, it just doesn't roll, as I mentioned before. If you could please make sure you're speaking into the microphone so we could hear you loudly and clearly. And then if you could start us off by stating and spelling your first and last name for the record, please.
Matthew Steele, Matthew
Great. Thank you, Mr. Steele. Whenever you are ready.
Yes, Your Honor. I would like to direct to the very first Exhibit A.
Okay. I don't think it's been offered. I have no idea what this document is. So when you're going to introduce exhibits, you have to let the court know what it is and how you have information about it and why it's relevant. So what is Exhibit A?
Exhibit A is the initial mental health evaluation that I did back in December. And that's after petitioner and I agreed to go through a mental health evaluation.
When you say December, do you mean December of 2024 or 2025?
2024, yes.
Okay.
And this technically fulfilled the court order under the roadmap on the cover page there. It's they completed two tests that are standard tests, the PHQ-9 and the GAD-7. And then the second, the first page of it, which is labeled page number 2 of 3, that describes basically the outcome of it, of what the mental health professional found at the VA.
So what is the document that's offered is page 1? Is that something that you created?
This is the cover page.
Yeah, who made this cover page?
The page is offered that says Exhibit A, page 1. I made the page 1 that says VA. And then the second page, which looks like it was printed by a government printer, that came from the VA healthcare facility. Okay.
And is this a complete document? I'm noticing it starts with item number 2.
No, I only cited the pages that I pulled out, but I'll gladly submit the full documents today as well.
Okay, so I'm not going to tell you what you should or shouldn't submit. Okay, so
I will gladly submit the full document of all of these. I just pulled out the pages so it wasn't confusing.
Okay, so these are this is a printout from some sort of evaluation created by the VA.
Yes, this is an official document that the VA served me with. And on the first page, under the roadmap, the overall findings, symptoms make daily functioning somewhat difficult, but not severely impaired. No thoughts of harm or...
I'm going to object here, Your Honor. This hasn't been admitted into evidence. And based on my objection are 1, late disclosure, 2, hearsay, 3, this is not a complete document, and 4, this first page is trying to circumvent testimonial evidence as a document exhibit.
Okay, so are you offering this document into evidence, Mr. Steele?
Yes, Your Honor.
Okay, and the petitioner has objected. What is your response to that?
So I offered this document to the courts during the first temporary order hearing. So petitioner has had this document for over a year now, the entire document. So just the snapshot, of course, is what I'm focused on today. And as far as the late submission, she did submit her entire brand new exhibit on the 5th of January. Of course, I objected to having these proceedings. And when I approached her this morning, I said, well, we can both ask for a continuance, so we both have a chance to look through each other's evidence. But of course, she said she was ready. So as far as late document submission is concerned, I don't see relevance in that. But.
Okay, so Ms. Winter, you're saying you've never seen this document before?
The first page, no. The second page I have seen as part of a larger exhibit. It's not the complete file.
Okay, so what I'll say is with regards to Exhibit A looks like a document that was just created by respondent and appears to be his own assessments of what the broader file might say. The court's going to exclude page 1, but the court is going to admit Exhibit A pages 2 and 3 for whatever value that it has. Frankly, it looks like the types of questions and answers you get when you see a mental health professional. The court, I've seen documents that look like these in many circumstances. So Exhibit A, pages 2 and 3 will be admitted. Page 1 will be precluded.
And I'm sorry, I don't have a page 3.
I don't either, Your Honor. I believe I just have 2 pages for Exhibit A.
Okay, so there is a page 3. It looks like just a signature or the signature block for Stephen Lee, the physician's assistant. So I'm fine with just page 2 then, if that's what everybody has. So page 2 admitted, page 1 excluded. So please go ahead, Mr. Steele.
So I'd like to focus on the PHQ-9 total score of 5, where it says 5 to 9 mild symptoms. That's for depression, which has been well documented, well controlled with the VA for the past 20 years. They knew this. And then I'd also like to point to the GAD-7 total score of 4, and that's for anxiety. That's 0 to 4, and that's minimal. So I acknowledge that I have some mental health issues, but they have been well controlled and well documented for over 20 years with the VA, and this document came from the VA.
I'm going to object, Your Honor, on the basis of hearsay, and also this would be grounds for expert testimony. I don't know what a PHQ is, what that consists of, what it entails, or a GAD.
Yeah, I don't know what the basis for that information is either. The objection is going to be sustained. Please go ahead, Mr. Steele.
So is this document just thrown out then?
Page 2 is admitted. The concern is about your testimony interpreting these documents, and that is typically you're not a mental health professional. You haven't been designated as an expert witness for the purpose of interpreting it. The stuff you're talking about is not stuff that's within the reasonably anticipated knowledge of a lay witness through reasonable perception or other observation. And so your testimony interpreting it is not going to be allowed, but the page is admitted.
Okay, absolutely. And then just to be clear, I can submit the entire document later today to the court.
We're here today and now doing this, so let's get through the testimony. Next, what else do you want the court to know?
Well, so I think that's it for that. I just wanted to point out that this was a document that was provided to petitioner after we both agreed to get a mental health evaluation. Petitioner didn't agree with anything about this document, but however, the VA did provide a full mental health evaluation, and this is a part of it. And I'm calling out just the scores that the mental health evaluation classified me as. I will move to Exhibit B, but of course, I'm sure we're not going to be focused on page 1. So I'd like to admit Exhibit B, page 2, 3, 4 into evidence.
And you have to let us know, what are these documents?
Sure. So this is a forensic mental health assessment by Dr. Bone. And this is the second mental health evaluation because, of course, the court didn't accept the first one from the VA. So I spent $11,000 and did a second one by Dr. Jonathan Bone. And this is these are his findings. And of course, on page 2, he has recommendations. And I would like the court to know that this mental health evaluation was based on police reports that aren't admitted today. And they are based on unsubstantiated and hearsay evidence that were earlier admitted into these proceedings. And I had to provide Dr. Bone with those. But of course, this mental health evaluation is based on those police reports that we're not using today.
So, Ms. Winter, my understanding, or at least my recollection, maybe I'm recalling something different. Were you going to object to the admission of pages 2 through 4?
No.
Okay, so page 1 will be excluded for the same reasons as previously provided, but pages 2 through 4 will be admitted into evidence.
Yeah, I would like to point the court to page number 2, the last paragraph. There does not appear to be a pattern of anger or violence directed towards his children and apparent earnest in his desire to see them more. And that's what he found. And that's about all I want to talk about on that one. And I would like to move to Exhibit C. And this, of course, is the PRE's findings. And it's the high-level summary of the evaluator's overall findings on parental responsibilities, including any noted strengths.
I
Recommend.
object, Your Honor, to this. Again, this is testimonial, and also the full report was already admitted as part of our exhibits. So if
Yeah, I guess what I'll say is if it helps you to kind of focus your, I mean, this is from the PRE report, and so this is already in evidence. So if you'd like to talk about, you know, what's in the PRE report and why you think it's helpful to you, I'd love to hear about it. But we already have these documents in evidence in a more complete sense. And that's for, is that Exhibit 1 or
C.
C? No, the full evaluation is Exhibit 1.
Yep.
Yeah.
Yes, correct.
Great, thank you.
That's fine, Your Honor. I do have one question about the motions that I submitted a few weeks ago regarding striking the PRE, and you accepted them, but they went to wait. So that's still
The motion to strike PRE.
I filed a motion, a limite motion for police reports, but that's not applicable. I filed a motion to strike the PRE.
Order regarding motion to strike PRE report and reimbursement of expense of expert fees. And the court issued a ruling saying that there was no certificate of conferral, so the motion is denied. And second, that the argument raised go to the weight the court might give to the testimony and to the report. But that just simply disagreeing with the report where the PRE is not a basis to strike the PRE or report or to get a refund. And so the court denied your motion on November 19th, 2025.
It was my understanding that the court was still going to wait the evidence I provided in there.
Well, the court's going to weigh what's in not what's in your motion. The court denied the motion, but to the extent you testify about things in the PRE report, the court reviews the PRE report similar to the way it reviews a child and family investigation report, meaning that I review it before the hearing, then we get the testimony at the hearing, and then I review it again after the hearing, because there are things that are put in the CFI or PRE report, in this case PRE report, that may not be supported by the evidence in the courtroom, or may be contradicted by evidence in the courtroom, or may be corroborated by the evidence in the courtroom. And so I don't rubber stamp what a PRE or a CFI ever gives to the court. It is a piece of evidence that the court will consider, that report. And to the extent you have anything that contradicts it, or should, if, for example, you present a testimony that the PRE had information that you were dishonorably discharged, but that was suggested that that's not true. That's something that, you know, challenges something that's in the PRE report. The court will consider that when it evaluates the report as a whole and decides what to do in this case. So whatever evidence you want to present that, you know, about the PRE report that you're able to present here today, the court will consider it in the context of that report.
Absolutely. So, well, I wish I would have known that earlier this morning. So the PRE report, I filed a motion to strike the PRE report for several reasons. One of them was the court had ordered us to go through both a psychiatric evaluation and a cognitive test. And I went through both of those. And petitioner did not. So the PRE report was based on biased results, and she didn't force petitioner to go through a cognitive test. So that's the first reason why I would like to strike that report. The second is I will get to later.
Okay.
Okay, so I guess I can omit Exhibit C if we're going to use, if the PRE report's already in.
Okay.
Is that?
Yep.
That's unfair. I'd like to admit Exhibit D, and this is based on the fact that police reports that were admitted earlier into this court that that allowed for a restraining order against me, that no action was taken. So I'd like to admit that.
And I'll object to D. First off, we have, first page is testimonial. The second, this is a very incomplete record. Third, it would be hearsay. Fourth, late disclosure.
Hold on 1 second. I'm not even sure I could read this.
Yeah, I apologize. That didn't print very well.
Just give me a second. Yeah, I'll note the objections. I don't necessarily disagree with the objections that are being made, but also I will tell you that I could barely read what's on page 2 of Exhibit D. The court's going to preclude page 1 as being testimonial and for the reasons stated. And page 2, the court will admit to the extent it can read or determine any information within that document.
Your Honor, what about page 3, the list of police reports? The police reports that have been certified and provided for release?
I don't have any of those reports, so I can't do all those. I'm not going to go look up those numbers.
Okay, it was more for the volume of the reports that came back benign. That was my argument here.
Okay. So, I mean, you can tell me that
Okay.
that's what happened. I don't have those reports, so those numbers don't have any particular meaning to me.
Absolutely.
Does that make sense?
Absolutely, yes, Your Honor. Which leads me to Exhibit E, which is the CBI report, and that is no record of any kind of criminal activity from my side.
Okay, so you're moving to admit Exhibit E?
Yes, Your Honor.
Any objection to page 2 or page 1? I guess I assume there's an objection to page 1.
Yes, objection to page 1. I mean, we're willing to stipulate that there is no CBI history. So if you want to admit to page 2, that's fine.
So the court's going to decline page 1. Court's going to admit page 2.
So, Your Honor, when this whole thing started last December, the court was presented with several police reports that were no more than parking tickets. It was me calling the police most of the time, concerned for my family's safety. And for some reason, I was painted as a danger to my children, and the CBI report just proves that I'm not a criminal, and I'm trying to make the right decision and get law enforcement involved when I need to if I see a problem, and not take matters in my own hands.
Okay.
Exhibit F, I'd like to move to Exhibit F, everything but page 1, and that, of course, is primarily the talking parents messages between petitioner and I about trying to get together with my kids.
Any objection to Exhibit F apart from page 1?
So this is it. The page 1 is saying it's a conversation about supervisors, but the pages after that are filed are some of the actually just one page about the discussion for therapy, which has already been admitted to the record. So I'm a little confused here.
I guess what I'll say is page 1 was going to be precluded either way. The remaining pages, which appear to be talking parents, for the purpose of focus, the court will admit pages 2, 3, and 4, understanding that it's something that has already been admitted. I don't really.
Yes, Your Honor. I believe those are the wrong pages anyway, so I don't know how those got in there.
Okay. Well, then I won't spend as much time on them if they're the wrong pages.
Yeah, I wouldn't take any. So the Exhibit G is the next one I'd like to admit.
Okay.
And that is the focus on Teresa's need for me, or I'm sorry, Ryan's need for me in her life, and how she has been suffering with the separation.
So you're talking about page 2. Where does page 2 come from?
Page 2.
The 9 of 56.
Part of the PRE report.
Okay. So is this a part of the PRE report, Mr. Steele?
Yes, Your Honor.
Okay. So we already have the PRE report in there. I'll just note that that page 9 of 56 is a page you want the court to focus on when I look at the PRE report again. But since we already have that in there, I don't see the need to readmit that. Okay.
I would also like to, is this admitted? I guess it is admitted then.
It's not admitted, but it's part of a document that's already been admitted. So I don't mind if you talk about page 9 of 56. That's already in the report. That's part of Exhibit 1.
Absolutely. Yes, sir. So I would like to call it, I've put 60,000 miles on my car, and that's 60,000 miles in about a year. And that's with no issues. And for a lot of the year, I had a little 8-year-old with me that I was taking around to fishing expeditions and basketball and skiing, and we were just little buddies. So I was being a dad, but of course not to my dad. And for most of last year, I drove around and I was, no issues. I was just being a good dad, doing good stuff. And that's really what I'm trying to call out here.
Okay.
Exhibit H, that really drives home the point of the substance abuse evaluation that was pushed on me. Page 2.
The 9 of 56.
Part of the PRE report.
Okay. So is this a part of the PRE report, Mr. Steele?
Yes, Your Honor.
Okay. So we already have the PRE report in there. I'll just note that that page 9 of 56 is a page you want the court to focus on when I look at the PRE report again. But since we already have that in there, I don't see the need to readmit that. Okay.
I would also like to, is this admitted? I guess it is admitted then.
It's not admitted, but it's part of a document that's already been admitted. So I don't mind if you talk about page 9 of 56. That's already in the report. That's part of Exhibit 1.
Absolutely. Yes, sir. So I would like to call it, I've put 60,000 miles on my car, and that's 60,000 miles in about a year. And that's with no issues. And for a lot of the year, I had a little 8-year-old with me that I was taking around to fishing expeditions and basketball and skiing, and we were just little buddies. So I was being a dad, but of course not to my dad. And for most of last year, I drove around and I was, no issues. I was just being a good dad, doing good stuff. And that's really what I'm trying to call out here.
Okay.
Exhibit H, that really drives home the point of the substance abuse evaluation that was pushed on me, not once but twice, by petitioner without any real evidence to support it. And of course, the PRE took petitioner's word for it and said, Mr. Steele, you have a substance abuse problem, even though you don't have any evidence against you, like a documented drug problem or a DUI or some kind of loss of job from alcoholism or something like that. It still got pushed on me, that $4,000 PRE, and I fought it several times with the court.
So are you moving to admit Exhibit H in then?
I'd like to move to
Any objection?
To page 1, yes. If he wants to omit the rest of the pages, sure.
Okay, so page 1 will be precluded for the same reasons previously described, and page 2 through 5 will be admitted. Okay.
Yeah, absolutely. And this was just to accentuate how aggressive opposing counsel was to try to get me into this $4,000 substance abuse evaluation, which wasn't needed, and for some reason the PRE supported it.
Okay.
Exhibit I, I'd like to admit Exhibit I, and this this is the total amount that was paid for the second psychiatric evaluation that I did after the VA did the first one. And of course, opposing counsel didn't like that one, and the court said, we don't accept that one. So I went through and I did another one, and I found somebody that would do another one, and he did a full-blown psychiatric evaluation, and he did a cognitive assessment, and he also assessed me for for a substance abuse problem, just to put the substance abuse issue to bed. So I had to stop fighting it. So I went above and beyond, and I spent the expense, and I just kind of said, I'll just go through it all. And I'd like to admit
Exhibit
I.
I. Okay, I assume the same objection to page 1. Any objection to page 2?
Yeah, it's the kind of the same thing. Is it in your, I'm not sure what it says in your book, but page 2 in my book is similar to page 1.
So page 1 is a paragraph from Mr. Steele describing the document. Page 2 is final invoice for psychological evaluation.
Oh, okay. I had 2 extra pages in between.
Okay, probably page 3 from the
Okay.
earlier exhibit.
Fine. I'm not sure it's relevant, but sure.
Okay, so page 1 will be declined. Page 2 will be admitted.
Yeah, and this is in there because I'm going to be asking for cost shifting.
Okay.
Because I had already completed one psychiatric evaluation at the VA, and of course the court, I specifically asked to have it done at the VA, and the court approved that. Technically, I fulfilled the court order with the psychiatric evaluation. But I, of course, with over litigation and ongoing issues, I was forced to do another one. So I was forced to eat this nearly $11,000 for the second evaluation to prove these claims against me.
Okay.
And then the third, I didn't list as an exhibit because it was this morning at 5 a.m. that got put on there. And I'm not sure how to submit that to the court, but it's basically my take on what I believe our financial situation is and what I believe child support should have been all year.
Well, first thing I'm going to do is I'm going to mark this as Exhibit J, just so it's marked as something in our books, and so that we're all talking. You're talking about the JDF 182 Child Support Worksheet A?
Yes, Your Honor.
Okay, and do you have that as well, Ms. Winter?
Yes, I do.
Okay, so we'll mark that as Exhibit J. Are you asking for this to be admitted as a demonstrative exhibit?
Yes, Your Honor.
Any objection?
Yes, first, untimely disclosure. Also, we've asked that Mr. Steele be barred from presenting evidence about his income apart from documents that have already been admitted.
So I guess what I'll say is this provides, because it's being accepted only as a demonstrative, this provides no actual evidence regarding Mr. Steele's income. It's just a worksheet being offered for demonstrative purposes. Ultimately, the court will make determinations regarding what income is or what it should be imputed at. Exhibit J will be admitted with those caveats as a demonstrative. Okay.
And I do have one more per our conversation earlier about my disability percentage. I did email opposing counsel an updated letter. Did you receive that?
I did.
Along with a snapshot of what is being deposited in my account. And I would like to know that Exhibit J, to my knowledge, as of today, is different. I believe it's $4,600, but I would like to get that information admitted into the court as well, now that I have that.
I don't have any other documents here. If there's something you're planning on testifying about,
And
we can deal with that, Ms. Winter.
I'm going to object to anything offering this new letter or testifying about it. Again, I received it just now. I also have some serious concerns about its authenticity. Earlier today, Mr. Steele stated that he already had this letter, and the letter I just received is dated today. It also has some conflicting information that I've received before. So especially with it being disclosed during the hearing, I have no time to properly examine it.
Yeah, I mean, without having the document, I can't really make an assessment about it either way. And if you're pulling out, I can't look at your phone. We deal with exhibits with physical exhibits here in the court. So it may be the basis for a motion at a later date, but I don't have this document in front of me, and I can't really do anything with it. I can't assess it or evaluate it. So at this point, the court's going to preclude it, but please go on, Mr. Steele.
Your Honor, may I submit it through the court digital system?
Well, I mean, we're here today. We're taking evidence today. So I don't, if you submit something after the fact, if it hasn't been disclosed and it's being provided after the fact, it will not have been cross-examined. So I'm not going to tell you can't upload things into the e-filing system, but that's going to be the problem with e-filing something after the hearing is done.
So during the hearing wouldn't count either?
I mean, I still don't have the exhibit. Just because you put something into the e-filing system doesn't mean I have the exhibit instantly. So
Can I make a few notes about that exhibit that doesn't exist?
I mean, you could let the court know whatever you think you want, whatever you think is helpful for the court to decide here today.
Absolutely. We had a conversation about that earlier today. So I logged into the VA portal and it produced that letter for me. That's why the date is today on it.
Okay.
And it's basically you go on and you log in and you download your benefits summary letter. And the benefits summary letter says that I have a 90% disability rating, but I'm at a temporary 100% disability rating at about $4,600. And that's really what the exhibit is. And I also took a snapshot of the last two deposits from the VA, which were December and November. And that amount was 4,000 something, whatever I listed on the
Okay.
The JDF.
The $4,080.
Yeah, and that's what it was last month, but this month it went up to $4,600. So of course my
Okay.
my income went up.
Okay. So is there anything else? So I have a lot of questions for you.
Yeah, absolutely, sir.
So, and I'm not asking these because I'm not, please don't view this as me putting my finger on the scale one way or the other. What I haven't really gotten from the testimony is what you're asking the court to do here. And I need to really understand that in order to make findings, regardless of how the court decides. So with regards to the children, for parenting time, what do you want the court to do for parenting time?
I submitted a parenting plan, which I believe is the only fair thing to do at this point in time because it's a high conflict case and a high conflict parent situation. Based on the fact that there's no real evidence that I'm a danger to my children, and the psychiatric evaluations continually say I'm not a danger. I'm asking for the courts to remove restrictions and to do a step-up plan. I would like 50-50 custody. I've been a stay-at-home dad for essentially 3.5 years. And I'd like to go back to that and just kind of play around with stuff and be an awesome dad and take my kids skiing. But I don't believe that I can co-parent. I spoke to the PRE about this, and it's not because I don't want to co-parent. It's because this is such a high conflict situation. And I've had some really terrible accusations against me that I've spent a lot of time and money trying to exonerate myself with. So I'm really asking the court to take into consideration my parenting plan. It's fair. It keeps us both in their life 50% of the time, which is what they need. They need us both. Teresa's an amazing mom. I wouldn't ever want those kids to not be around her. And I'm the same. I'm an equally as good dad. I'm looking forward to playing with them and teaching them stuff. And I am such a crafty person, and I'm an athlete, and I'm everything that those kids want to grow up with. I'm not a couch potato, sit on your couch, go bowling every Tuesday and come home drunk kind of a dad. I'm a good dad. So parenting plan is my only option that I can come up with that we can move forward. And that keeps Teresa and I away from each other enough, but close enough that I'm hopeful that we'll be able to be amicable in the future. We'll be able to move past the past year of our life of this situation, which isn't good for anybody. But
so you're talking about the parenting plan that you filed on January 5th in the evening. Okay. I just wanted to make sure that that's what you were referring to.
Yeah.
I'm going to treat that as being basically an adjunct to the trial management certificate for the purpose of this hearing. I will review that, but I just wanted to make sure it was on the record what you were asking for and why you were asking for it. So similarly, with regards to decision-making, if you remember, we talked about joint or sole decision-making being the options, and the medical, educational, extracurricular, and religious or spiritual upbringing. It looks like you're asking for each parent to have sole decision-making authority for the child residing with that parent. So you actually want one of the children, Ryan, to live with petitioner full-time and one of the children, William, to live with you full-time. Is that correct?
Well, right now, yes, because we're still high conflict, but ultimately I don't want that.
So how does that work for the children, for siblings to be separated like that at that age? How have you thought about how that might impact them?
Yes, I have. And I'm hopeful because Teresa's family is here and she's surrounded by other children. That's a good thing. But what I would really like to do is get them Gab phones and make sure that they can call each other whenever they want, wherever they are, get them Gab watches. They're essentially iPhones but for kids. And I want them to be together all summer. But then just swap between mom and dad's house. And then I want them to be together every holiday, but swap holidays between mom and dad's house. I want the kids to be together as much as they can, but I don't want the mother and I to be together and continue to fight until we can learn how to get along and move past this stage of our relationship.
Okay, and so your decision-making idea is that, at least initially from your request, that Ms. Clark would have decision-making for Ryan, and you would have decision-making for William because Ryan would be living with her and William would be living with you.
Yes, that absolutely.
And then even under what you've described here today, you contemplate at some point the children being back together. Then what would you contemplate at that point for decision-making?
Well, I'm hopeful that it will be more co-parenting then. And I don't know if that's a year or 4 years but I'm hopeful it's not that long.
Okay. Is there anything else you want the court to know that we've kind of gone through here?
Yes, absolutely. So as far as child support, my fixed income is a little over $4,000 now. It's $4,600 this year. The president gave me a raise. And of course, petitioner is doing very well in her career. I would very much like for the court to reconsider the back pay of child support that I owe based on petitioner's current yearly salary and my current situation. I would also like the court to take into consideration the immense amount of unsecured debt I have and the fact that when petitioner left me financially, I was left with a $30,000 credit card bill and a mortgage, and I'm barely floating financially right now. So if there's any money that the court's going to issue me to pay her, I'm going to have to pay her $1 a month or something. I'm just not in that position. So I want the court to know I'm broke.
Okay. Anything else?
I think that's it, Your Honor.
Okay. I'll give Ms. Winter now a chance to cross-examine.
So, Mr. Steele, apart from some anxiety, you don't believe you have any mental health issues?
Objection, HIPAA.
I feel like we've been talking about this for the last 3 or so hours. This is not covered by HIPAA. The objection is overruled. You can answer.
According to the Veterans Administration, I do not have any other mental health issues.
But personally, do you think you have any other mental health issues?
I don't know the answer to the question. The objection's overruled.
I believe the VA. I believe my primary health care provider when they tell me that I don't have any major health issues as far as mental health is concerned.
Okay. Could you turn to, in the big binder there, Exhibit 18, please? So this is your sworn financial statement that was filed March 24th of 2025. Does this look familiar?
Yes, it does.
And does this appear to be a true and accurate copy of that?
Current, no, it's not current as of today.
But of this first sworn financial that you filed?
As far as I'm concerned, yes, it is accurate.
All right, move to admit 18, Your Honor.
Any objection to that, Mr. Steele?
No.
Exhibit 18 will be admitted into evidence.
And this is the only sworn financial statement you filed in this case.
Yes, correct.
And you never filed a certificate of compliance.
I'm not sure what that is, so probably not.
Now, do you recall we attended a pretrial conference on December 15th?
I do.
And during that, the court warned both parties that failure to provide financial disclosures could result in sanctions.
I do.
And the court also ordered you to provide information related to your employment and any gig-related work within 7 days. Do you recall that?
I do.
So you do have income through your company, Juniper Technologies, LLC. Is that right?
No, that's not true at all.
May I approach?
Sure.
So I just handed you an email you sent me on December 23rd, 2025. And I'm reading the highlighted section here. It says, for clarity, Juniper Technologies LLC does not generate income from gig work. The company's income is derived from short-term rental activity operated through the S Corp, not personal or platform-based gig income. Did I read that correctly?
Is this being admitted as evidence, Your Honor?
I'm not sure what it's being offered for at all at this point. I think she's just trying to impeach you.
It's just being used for purposes of impeachment.
So it's not being offered as evidence. She is asking you questions about it, which she is able to do.
Yes, you read that correctly.
All right, thank you.
Do I get a chance to rebut that?
You'll get a chance to read the record to make a statement addressing anything that came up in cross-examination when she's done, just like we did with Ms. Clark. So,
And you're the sole member of that LLC, is that right?
That's an S Corp.
You're the sole member of that S Corp?
Yes, I am.
And you formed that LLC or S Corp, if you want to call it, in 2022, is that right?
I don't recall.
Would seeing a copy of the Articles of Organization help you recall?
I mean, if you have them and if you know that if that's the date, then I'll trust you with that, but I just don't recall.
Okay. I guess, let's say, would you agree that it was formed before this case was filed?
Well, I've pulled a tax ID number before, yes.
You didn't disclose Juniper Technologies on your sworn financial statement, correct?
I did disclose the bank account.
Okay. And that was it?
I don't recall.
Okay. And you claimed you were unavailable in all of November and December because you'd be out of the country on a new project. Is that right?
I did.
Okay. And you have not disclosed anything about that employment on your sworn financial statement?
I don't consider that employment.
Okay.
Being an executive of an S Corp isn't an employment.
And you've also formed a new holding company where you have 2/3 ownership interest. Is that right?
That's correct.
Okay. And you haven't provided any disclosures for that interest.
It's newly formed.
You were also recently awarded 2 patents. Is that right?
Only one that I'm willing to discuss at this public hearing.
Okay. You haven't provided any documents on those patents.
I have provided them publicly, yes.
Publicly, okay. They were not provided to myself or Ms. Clark.
In what respect?
In terms of financial disclosures or any business related to them.
They have no value.
And so you were well enough to travel for 2 months for work, November and December?
No. I'm not gainfully employed, so that's not work.
Okay. But you're well enough to form and operate an LLC, Juniper Tech.
Well enough in what respect?
Just general operating abilities. You're allowed to manage it.
It's like
And-
mental health capacity?
Yeah.
Yes, I consider myself mentally stable to do that, yes.
And you're well enough to obtain 2 patents. By well enough, I mean you have the capacity to do it. You went and did it. You filed all the paperwork.
I'm well enough. I don't see where you're going with this objection.
The objection's overruled. You can answer.
So I have the ability to file 2 patents in 2022.
Okay. So if you would turn to Exhibit 29 in your binder there, please, the big one. This is an email exchange between you and I on December 18th, 2025. Do you recognize this?
Is this one of the frivolous ones?
If you want to call it that, sure.
Is it listed in your frivolous list?
I do not have a frivolous list. Are you referring to the affidavit of attorney's fees?
Yes.
Probably.
Okay, so this is considered a frivolous email then?
I would say so, yes.
Okay.
Does this appear to be a true and accurate copy of our communication via email?
I can't confirm that, but it appears to be.
Would move to omit 29, please.
Any objection?
I do object. She's claiming it's frivolous.
That doesn't really get to the question of whether or not it's admissible. Exhibit 29 will be admitted into evidence.
I'm sorry, I'm not sure who we're waiting on here. Is it?
I think we're waiting on you to ask if there was a question pending.
Oh, was it admitted? I think we're waiting on if.
I already admitted Exhibit 29.
Oh, okay. I'm so sorry. So on the top of this first page here, you were asking for confirmation of the therapist's name, practice, and contact information. Do you see that there?
Yes, I do.
And if you go to page 3 of that exhibit, which is earlier in that email chain, I gave you that therapist information. Do you see that on top of page 3?
I do, yes.
And Ms. Clark had also given you that information multiple times via Talking Parents. Is that right?
I don't recall that, no.
Do you remember that we had a status conference on November 7th?
I don't recall the conference.
And do you recall at that point, during that conference, the court advising the parties about the use of AI?
No, I don't.
Would seeing the minute order from that help you remember?
No, it wouldn't.
Okay, I'll ask that the court take judicial notice.
The court's already taken judicial notice of the file and the orders issued by the court. Sorry to cut you off.
No, we're all good. And you filed a motion to vacate a support judgment on November 26th. Do you remember filing that?
I do, yes.
And you cited to legal authority that didn't exist in that motion. Do you recall doing that?
No, I don't.
Right. I have no further questions.
Okay. So as I mentioned, Mr. Steele, you have the ability to, for lack of a better description, redirect and address the issues that were solely raised by Ms. Winter in her direct examination or cross-examination of you. Is there anything you wish to let the court know in response to that testimony that you just gave?
I do, yes, Your Honor. As far as AI is concerned, it's still legal to use in the courtroom. And I've used it extensively to try to circumnavigate this process. I appreciate your patience with me, Your Honor.
Okay.
As far as the impeachment, I formed a company in 2022, and it didn't make any money until about 6 months ago, and I rented my house out as an Airbnb. And that money is being used to subsidize the money that company is hemorrhaging. It is completely upside down and inside out. And if it's successful, opposing counsel will not be upset because there will be a lot of financial freedom for our children. But if I fail, I'm going to file for bankruptcy. So as far as this impeachment play is concerned, I do not have personal income and I do not have gig income from that company because it is set up so I don't have to pay taxes twice. And that's the whole point of an S Corp.
Okay.
And as far as my mental health is concerned, I did file a motion. Is it a motion to limite?
Eliminate.
Okay, I apologize about that. That my mental health would no longer come up in court because I thought I proved the basis that it didn't need to. So I did file that motion. It was denied on procedure. I do believe it was accepted, and it was going to be accepted into the final orders hearing as weight only. I believe I filed four motions all at once, and that was one of them. So I'd like to make note of the court, for the court to make note that I was trying to put this whole thing to bed. And I thought I provided a lot of evidence and a lot of proof that my mental health is no longer in question.
So let me just tell you, is that all the testimony?
I'm sorry, sir.
Is that all the testimony?
Yes.
Okay. Is there any recross limited to the scope of redirect? Thank you. You could step down, Mr. Steele. And just for the record, you could just leave that stuff up there.
Oh, this one's mine.
Oh, okay. Got it. Just for the record, Ms. Winter nodded her head. No, I don't think I heard you actually say no.
Oh, I'm sorry. No.
I was just noting it for the record. I didn't mean to call you on the spot there. I did want to address one thing that Mr. Steele raised here. Mental health is always going to be relevant because the court is required to consider the mental and physical health of all individuals involved when determining what the best interest of the children are going to be. So that is a factor that the court has to consider in this case. And so the court would never just preclude evidence regarding somebody's physical and or mental health. Do you have any other witnesses, Mr. Steele?
Yes, I'd like to call Miss Teresa Clark.
Okay. Ms. Clark, you could retake the witness stand. I'll just note for the record that Ms. Clark already extensively testified, so.
Can I object to this, Your Honor?
You can. If you want to make a record, I'll let you.
No, go ahead.
I don't want to stop you from making a record.
No.
Just because I think I'm tipping my hand as to which you can step on. You can have a seat on the witness stand. The short version is he does have the right to call the other party as a witness. The court is not going to allow us to go through the testimony that we've already gone through. I know, Ms. Winter, that you're probably going to make an argument that the court already allowed him to go outside the four corners of the testimony. He's not represented by counsel. I know the rules apply to folks who are not represented by counsel, but the court is also required to basically construe the rules liberally to ensure that substantial justice takes place in this hearing. So the court is going to allow, but we are not going to go over testimony that we've already covered. I'll remind you, Ms. Clark, that you do remain under oath. So, Mr. Steele, whenever you are ready.
Thank you, Your Honor. Ms. Clark, please turn to Exhibit D. Be the third page, reports that have been certified and provided for release.
Okay.
Do you recall pulling police reports with my name on them?
Yes.
Do you recall submitting those police reports to this court?
I recall submitting them as part of the temporary protective order process.
What in those police reports generated fear in you?
I believe the dispatch agent talked about mental health issues of you when you called in.
Do you believe that dispatch agent is certified to comment on mental health?
I believe they have extensive experience and they have vernacular when they report on this, and it was included. It seems like it's a part of their job that they're aware of.
Do you believe that that individual is a certified healthcare provider?
No, it's a dispatch agent.
So do you believe that somebody that's untrained in mental health has the ability to make comments on another person's mental health?
Objection. This has been asked and answered.
The court, the objection is going to be sustained. If you want to ask specific questions about the dispatch agent, that's fine. But broadly speaking, I think we've already covered this. So next question, please.
So do you believe these police reports are still valid?
Yeah,
Why didn't you provide these police reports today?
they're already part of the court and the testimony back in April.
Do you recall the Judge Klein saying earlier today that the police reports were not a part of this case today? They won't be considered?
Yes.
So do you believe that they should be considered as a part of this case?
I'm going to object here. I think this question goes to a protected client attorney privilege communications about case strategy.
I don't know that it gets into that, but whether or not the witness thinks certain documents should be considered by the court when those documents are not currently before the court is not really, it's not really something the court has to decide or is going to decide. So the objection is sustained.
Can you turn to Exhibit E, please? Can you tell me what this document is? It's the second page. The first one is omitted, of course.
It's a Colorado Bureau of Investigation page.
And can you explain what this document says about me?
That there's been no Colorado record of arrest.
So what does that mean to you, Ms. Clark?
That there's been no Colorado record of arrest.
To your knowledge, have I ever been arrested?
In Hawaii on a domestic violence case, yes.
Do you have proof of that?
No. Besides what you told me.
Do you have proof that it's on the record? Did I also tell you that it was expunged?
I don't recall.
Can you please turn to Exhibit A? Second page. You have your degree in psychology, is that correct?
Yeah, Bachelor's of Science.
When you look at this PHQ, when you just look at this document, does it look like something that would be an evaluation, a psychiatric evaluation?
Objection. I think this is trending towards, I'm not sure, maybe trying to qualify her as an expert, or we've already established that testimony on what PHQ entails is grounds for expert testimony, which Ms. Clark is not.
And she hasn't been designated as far as I can tell. The objection is sustained.
Yes, Your Honor. Did you read through this original report when it was given to you?
I believe it was sent via an email and showed that it was administered by a physician's assistant and that it consisted of 16 questions. And to me, those felt like standard office visit questions. How are you feeling today? How well are you sleeping? So I remember that, yeah.
So you agree it was completed by a medical professional to evaluate a specific situation?
Yes, it was completed by a physician's assistant via text or email.
Did that physician's assistant work for a mental health facility?
I don't know.
Did this come from the mental health facility at the VA?
I don't know.
Have you seen this entire document before, Ms. Clark?
Maybe back in February of 2025.
Do you recall this document, the entire document, being admitted at the first technical orders hearing?
Yes, and that it was ruled woefully insufficient for the means of a psychological evaluation.
Do you have those minute orders, Ms. Clark?
I don't.
But you recall that it was willfully, and what did you say it was again?
It did stick in my head that it was woefully insufficient
Willfully insufficient. And for the reason, do you recall the reason?
to meet the terms of a psychological evaluation that you and I were both asked to undergo.
And what were the rules around that psychiatric evaluation?
It was a psychiatric evaluation.
Was there anything else that the court ordered us to do?
No, and I don't recall any ask of a specific cognitive test.
So you don't recall in the court order, the judge specifically stated psychiatric evaluation and cognitive assessment test in the court order?
I don't recall the entire language, no.
Did you know that we were both required to get a cognitive assessment?
Yeah, the standard psychological evaluation that you usually undergo for allocation of parental responsibility cases.
And did you go through a cognitive assessment?
I believe that the tests that they administer are considered cognitive. So I don't believe an intelligence test automatically qualifies as the only cognitive test. I think the personality and whatever other tests they administer met the needs and requirements of the court order.
So that sounds like an expert testimony, but based on your degree and your background, I can expect that. So you believe that you don't need to go through a separate cognitive test that's called out in the court order?
Objection. This is asked and answered. I'm not sure of the relevance here. If we're going to debate what it is or is not a cognitive test, that's, again, as Mr. Steele just pointed out, grounds for expert testimony.
I'll allow this one question, but we probably should be moving on beyond this question. So the objection is overruled. You could answer if you're able to.
Will you ask the question again, please?
We can move on, Your Honor. I think I made my point. Thank you. Turn to Exhibit B, please. Have you read through this entire report from Dr. Bone?
When we received it, I think in September, I did read through the report, but I remember it being much longer than this.
This is just a snapshot. So, do you agree that the conclusions on this mental health diagnosis, there's no current psychosis or violent risk based on page number 3 under the recommendations?
No, I agree that it states that you meet the diagnostic criteria for delusional disorder, persecutory type, first episode currently in partial remission with features of grandiosity. Although I will note when I read that, I believe that you were probably not fully disclosing your feelings of still being stalked. I don't think that just goes away. So the partial remission, I didn't necessarily agree with.
So you're aware that this forensic mental health assessment by Dr. Bone was completed. I asked you this earlier, and I apologize to repeat myself. But you're aware that this evaluation was completed based on the materials that opposing counsel that you had provided to the court. So the police reports, the photo of the mug, the stories, the hearsay, all of that. You realized that everything you presented to the court, this psychiatric evaluator evaluated along with my mental health.
Objection. In proper form, I'm not really sure what the actual question is.
Ms. Clark, did you understand the question? The objection is sustained, but you can re-ask the question, maybe break it down into a couple of pieces if that makes more sense.
Yes, Your Honor. So did you provide the court with police reports and photos of, me throwing a mug against the wall? And did you provide the court with evidence that could be a risk?
To the court for the temporary orders hearing, yes, I believe those were the exhibits.
And do you recall during the temporary orders hearing, I was ordered to provide that material to my psychiatric evaluator?
I don't recall the terms of what you had to provide to your own evaluator.
When you read this report initially, do you recall that what this test was based on? It was based on all of those reports. It was based on all of the evidence you had provided the court. I'm asking you, do you understand that this report is based on your evidence?
I believe from what I read from Dr. Bone's evaluation and summary was that it was interviews with you, and maybe it's even on the payment statements, but it was interviews with you, interviews with your ex-girlfriend Summer, your own, however, testing, the personality tests that they ran. Yeah, that's.
So would you believe me if I told you that I gave Dr. Bone all of the evidence that you presented against me because the court ordered me to?
Sure.
So you believe that. So you believe that this report is based on those police reports and that the initial evidence that you provided to the court?
Not fully. I believe it's mostly based on the tests that they run during psychological evaluations.
I'd like to refer you to Exhibit A, please. Do you believe that this test was completed based on that evidence that you provided the court?
No.
So do you believe that the evidence you provided the court prompted Dr. Bone to write his report a little bit differently than Dr. Lees wrote his?
No, I think these are two completely different types of tests. Like I said, I think this is a office questionnaire of only 16 questions, whereas I think a psychological evaluation is way more robust and has the personality tests and everything that goes along with that. And I believe that's by law probably what those professionals have to use to write their recommendation.
So do you agree that they're both mental health evaluations?
I actually don't know if a questionnaire is considered a mental health evaluation.
Well, you've seen that report. Is it listed as a mental health stability? It's VA mental health stability by Lee evaluation. Do you agree with that?
No, because the page that you're referring to is what you wrote yourself. And I don't see that on what looks like an actual test.
So you don't believe that Exhibit A is a certified mental health evaluation from a federal entity?
Objection. This is miscategorization of evidence. There is no certification on here.
Well, then she can answer that it doesn't appear to be one. I mean, I guess, so the objection is overruled. The witness can answer. I don't necessarily disagree with counsel's assessment of it, but.
No.
So you don't agree that this is a certified version? The original version that I gave you, you don't agree that that was a certified mental health evaluation from the VA?
No, again, because I don't think that a 16-question questionnaire, it doesn't seem like the 16-question questionnaire is like a legitimate full mental health evaluation.
Did you know that Dr. Lees was my mental health provider in 2020 and 2021?
No.
You didn't know that I had a 4-year history with Dr. Lees and I saw him after Ryan was born?
No, and I didn't know physician's assistants were mental health professionals either.
He's a certified mental health professional.
Objection. This isn't a question. This is testimony.
The response is not a question. The objection is sustained. Next question, please.
Please turn to Exhibit H. Do you still believe I have a substance abuse problem, Ms. Clark?
In our history together, I would see it as likely that it is still a problem, but I have not been around you since we separated.
What evidence do you have to make the claim that I have a substance abuse problem?
Everything I witnessed over the 7.5 years we were together,
What evidence do you have?
my own testimony.
So you believe that I have a substance abuse problem.
Yes,
Do you believe the VA would flag that?
I don't know anything about the full VA testing and measures, but in Dr. Bone's own report, where they do test for that, it was flagged and noted as a problem.
Now, do you remember the verbiage in that?
Not exactly, no.
Do you remember that Dr. Bone said, I may have a substance abuse problem, not that I do have a substance abuse problem?
I would have to go back and read for that term.
Do you recall that coming up at the second technical order hearing?
The second technical order
Sorry, temporary order hearing. Military terms coming out.
in October.
Yes.
I remember you being asked a question about your own mental health and you saying, I forget how you phrased it, but like, oh, it is likely. So I remember that term.
This is about substance abuse, not mental health.
I don't remember which portion that was, but it was in addressing Dr. Bone's evaluation.
So you don't recall my response is that Dr. Bone said I may have one, and I don't believe I do have one.
No.
Thank you. Ms. Clark, when is the last time you responded to one of my messages on Talking Parents requesting time with the children?
I would have to look back for the date, but November, December, late November or early December
Have you
or
ignored?
mid-December.
Have you ignored ones recently?
The last message I may have not responded to, but the reason was you had repeated the same ask, maybe, this is just a guess, but like 8 times. And I had just restated the court orders and that your requests were outside of that and tried to offer different supervisors, but that never went anywhere. So I decided it was probably in the best interest to no longer respond.
So what was the ask? What was I asking for?
Parenting time using your Aunt Carol.
So I was pretty adamant about asking for parenting time with my Aunt Carol as a supervisor then, correct?
Yes. And it was once in late November and twice in December. And then prior to that, I think that was July. And prior to that, it was March. So they've been pretty sporadic.
And how many of those did you approve?
The last 3 that you requested, I denied. And the ones in July, I denied.
So you denied my request. And what did you offer as an alternative to Carol again?
My sister Katie was available the same weekend you were asking for, and I had asked her if she'd be comfortable supervising, and so she said yes, and I offered her as a supervisor.
So your family are okay as supervisors, but my family are not okay.
I'm going to object here. We've been over this extensively.
The objection sustained.
I just want to drive it home. Thank you, Your Honor. I think we're there now.
Any other questions?
I do have just one more, and it is in regards to Exhibit C, but of course you don't have to look at Exhibit C because it's already on the record, and it's about the PRE's findings and suggestion. Did she suggest a step-up plan?
Yes.
And do you agree with the step-up plan?
I agree with a step up phased parenting plan.
What do you think the
reintegration.
best way to get those children back in my life is?
For you to go get the psychological help that you need and treatment and stick with that treatment.
So what if my primary care provider says I don't need it? Would you accept that?
No, because there's conflicting information from other expert psychologists who did their own tests.
So what if my primary care provider has been my primary care provider for 20 years? Do you think I can pull the wool over their eyes for 20 years?
You are rather convincing.
So you believe I'm pulling the wool over the Veterans Administration's eyes because of mental health?
I don't know what you say or do in your primary physician visits. All I know is what I experienced and what the psychologist and the PRE's findings.
Are you aware the first time I attended mental health at the VA was in 2005?
No,
Are you aware that I've been in and out of mental health since 2005?
I don't know what that in and out of mental health.
So if I feel a little sad, I'll call my doctor and say, hey, can you get me an appointment with mental health? And my primary care will say, yes.
So a department.
Yeah, mental health department. It's mental health and primary care.
No, I'm not aware of your history.
Are you now aware that in 2020 and 2021, Dr. Lees was my mental health provider?
Yes, because you just said so.
So now are you aware that I have been in and out of mental health and have sought their services, and I'm not scared of mental health for over 20 years?
Again, I don't know what you had earlier, and I don't know how, well, I guess you said the physician was trained as mental health. So if you've been seeing them then, and they're trained in mental health, then yes, I would say, yeah.
So if they were to tell you that I don't need any additional help and I don't have any major psychological issues, would you believe them?
Objection. This has been asked several times.
The objection is sustained. I think I already know this witness's answer from having heard it several times.
Thank you, Your Honor. No more questions.
Do you have any cross-examination?
No.
Okay, great. Thank you. Ms. Clark, you can step down from the witness stand. Any other witnesses, Mr. Steele?
No, Your Honor.
Any rebuttal witnesses from the petitioner?
None.
Great, thank you. So that concludes the evidentiary portion of the hearing. Each side will now have an opportunity to make closing remarks. Ms. Winter, whenever you are ready.
Yes, Your Honor. So the struggle we face here today is that Mr. Steele is ill. This is not an illness he asked for, in any way deserves. It's not his fault. And millions of people every day are diagnosed with diseases, cancer, heart disease, MS, bipolar. And while we don't get to choose our disease, we do get to choose what we're going to do about it. And the issue here is that Mr. Steele has chosen not to recognize his issues or to pursue treatment of it. And it's gotten to the point where it's no longer safe for him to have the children unsupervised. Under 1410-124, in order to continue the restriction on Mr. Steele's parenting time, the court has to find that Mr. Steele having unsupervised time would pose an imminent danger to the children's either physical or emotional health. And it appears that Mr. Steele argues that maybe because the VA only signed him a less than 100% disability, this is somehow indicative that he has no mental health issues and is a safe parent. It seems most likely that Mr. Steele has not informed the VA of his diagnosis, and they are not privy to the reports that were issued in this case. And it's entirely possible for someone to be 100% disabled for purposes of working and benefits, such as somebody who is a quadriplegic, and still be a totally safe and fit parent. And the reverse is also true. Ultimately, disability rating is not the determinative factor here on whether somebody is a safe and fit parent. It's a totally separate analysis. And the exhibits in Mr. Steele's behavior throughout this case speak for themselves. Ms. Clark has testified that she would love to have Mr. Steele be a part of the children's lives, but until he gets the proper treatment and addresses his mental health issues and substance use, that's just simply not safe to have any unsupervised time. We're asking the court order parenting time in line with the proposed parenting plan that we submitted today. Also, given the extensive filings in this case, I also want to reiterate the plan that we submitted, the part of it that states that Mr. Steele cannot move to modify parenting time until he is in phase 3. Moving on to decision-making, it's very clear that the parties cannot make decisions jointly, and Ms. Clark should continue to have sole decision-making. We're also asking that she shouldn't be required to continue to confer with Mr. Steele in advance of making these decisions. The record shows that Mr. Steele responds to these conferrals either extremely late, by asking mother for information he could already obtain for himself, or by hyper-focusing on something that's not actually relevant to the decision at hand. I believe that continuing on with this conferral requirement would only open the door for further never-ending litigation by having Mr. Steele, affording him the opportunity to consistently allege that Ms. Clark has not followed through or properly followed the conferral process, and that is not in the children's best interests. For child support, we ask that it be ordered in accordance with the statutory guidelines, using the income on Ms. Clark's sworn financial statement, and then crediting her for what she pays in healthcare, childcare, and also therapy. 1410-115 5B1 states that if a parent is voluntarily underemployed or unemployed, child support must be based and calculated on a determination of potential income. Except that a determination of potential income cannot be made for, among a couple things, a parent who is physically or mentally incapacitated. The VA has determined that Mr. Steele is only partially disabled, so that doesn't meet the requirement to prohibit the imputation of income to him. Further, we heard today that Mr. Steele is currently involved in multiple business ventures, generating an unknown amount of money. We're asking that he be imputed an income of $10,000 a month. This comprises of the VA disability benefits of about $4,600 he just testified to, and then the rest of that being an estimate based on his, undisclosed assets and employment, earning history, his rental income. The case People v. Martinez, and that's 70P 3D 747, dictates that the income imputation inquiry must start with whether the parent is shirking a child support obligation. Mr. Steele's ongoing refusal to provide mandatory financial disclosures throughout this case, and his failure to pay any child support since July, and his pulling his house from the market days after Ms. Clark obtained a child support lien on the property, are all the actions of somebody who's attempting to shirk a child support obligation. There's a number of factors in 1410-115B5-2 that lists what the court has to consider in determining potential income. I'm not going to discuss each of those factors, but I will assert that as a whole, they all weigh heavily in favor of imputing income to Mr. Steele. Regarding the request for bond that's been made today, payment hasn't been made since July for child support, and Ms. Clark has been unsuccessful in obtaining an income assignment on the only source of disclosed income that father has in this case. 14-109 allows parties to request that the court order obligors to post security, a bond, or other form of guarantee to secure payments of the child support ordered. In addition, 1410-118-2 grants courts a broad authority to require security to ensure the enforcement of their orders.
Well, can you just give me that last statutory site, please?
Yep, 14-10-118-2.
Great, thank you, sorry.
Oh, no problem. The case In Re Marriage of Yeager, and that's 883P2D 577, states that the amount of security established to ensure payment of a support obligation must be reasonable in both amount and duration. And in that same case, the court ordered security equivalent to the total amount of payment, meaning the monthly amount times the total number of months. And the appellate court in that case upheld that as being a reasonable amount for bond. So we're asking that the court impose bond in this case and use the same calculation that was used in Yeager. Finally, in regards to attorney's fees, we are requesting attorney's fees be awarded for Ms. Clark pursuant to 1417-1024. Now, subsection 6.
1317-1024?
1317.
Okay. I thought you said 14. Sorry.
Oh, no, you're right. 1317-1024. And of course, subsection 6 of that statute states that attorney fees shall not be assessed against a pro se party unless the court finds that the party clearly knew or reasonably should have known that that party's actions or defense or any part of the case or defense was substantially frivolous, substantially groundless, or substantially vexatious. Another instructive case on this point is Thompson v. Thompson, and that's 198 P3D 1281. And that established that a vexatious claim, as would support an award of attorney's fees against a pro se party, is one that the pro se party knows or reasonably should have known is brought in bad faith. Frankly, I've lost track of how many motions Mr. Steele has filed that the court has denied due to lack of conferral, and yet Mr. Steele keeps doing it despite countless warnings. Father's motion for overnight transcript was denied, and 20 minutes later, he filed the exact same request for a same-day transcript. Sending an attorney 10 emails a day on numerous occasions is not reasonable. And as reflected in some of the court's orders, and despite, again, multiple warnings, Mr. Steele continues to use AI in pleadings without checking the sites for accuracy. This is textbook vexatious behavior, and I am exhausted. Since the affidavit of attorney's fees was filed, Ms. Clark has had to incur additional attorney's fees related to additional motions that Mr. Steele filed that we assert are frivolous. We are asking for leave to file an updated attorney fee affidavit to include those, and potentially what I anticipate will be a barrage of additional filings. Currently, the court has excused Ms. Clark from having to file a response to these pleadings filed by Mr. Steele, and in an effort to keep Ms. Clark's attorney fees in check in the future, we would ask that we continue to be excused, and if the court would like a response, to let us know. Thank you.
Okay, thank you. Excuse me, Mr. Steele, you have the opportunity to make a closing statement if you wish to do so.
Yeah, I do. I'm here about my kids. I am more than happy to pay child support and support them. I don't have a lot of money and I got a lot of debt and a lot of bills, but I'm a resourceful individual and I'll make it happen. So it's not about the child support. And, I dispute the calculation, not the fact that I have to pay them. I dispute the fact that I don't get to be their dad. That's the biggest reason why I'm here. But I'm not trying to make this about money, Your Honor. I've spent everything I had fighting it for the first 10 months on lawyers. I think it's over $22,000 just for that amount of money. I didn't have a choice but to go pro se. And that's where I am. I would love to be able to afford an attorney just to fight the fight for me so I don't have to deal with the headache. But so as far as attorney's fees are concerned, I understand they are painful. And out of the two of us, I'm the one that can't afford to pay them. But we are here for the children. And I've complied with all the court orders, all of them. And there have been no safety incidences. There have been no actual real police reports. I am just a concerned father trying to protect his children. And I do have mental health issues. They are mild. Like most people, I have mild anxiety and mild depression, and they've been well controlled for a long time. And my medical provider went to bat for me, and they will still go to bat for me and say, these allegations are absolutely absurd. I was a father reacting to circumstances, and I will do it again because I love those little kids. And that's all that was. So I never put those kids in danger. I never put Teresa in danger. The whole point was to get them out of danger. That's why my actions are my actions. As far as my employment is concerned, I have been a fully disabled veteran since February of 2022. So my ability to earn income is $4,000 a month fixed income from the VA right now. And the VA had said, you're at a 50% disability rating. And I got a lawyer and the VA said, whoa, hold on. We're going to put you at a 90% and then we're going to put you on 100% until you get back on your feet, until you feel like you can go back out and do this. And one of the big reasons why I'm not really motivated to go back out and do this and go back out and get beat up in the real world is because I want to be a stay-at-home dad. And the VA has said, you know, if you can't be a great dad and be a great employee, then just go be a great dad. And I have that luxury right now. And I'm going to continue to do that. And this isn't about my ability to make a lot of money. It's about my ability to be a good dad. That's where I am. And I've given up a huge career and a lot of money to do that. It's been stripped from me for the past year. I'm hopeful that's going to change. I'm hopeful I'm going to get back in their lives. And, you know, I shouldn't say this, Your Honor, but I'm being treated like I did a bunch of meth and beat up my kids. And I understand the mechanisms in place that put me here. It was over litigation from day one. They want to complain about attorney's fees. I want to complain about having to hire an attorney, period. This could have been solved amicably. It wasn't, so here we are. So I didn't hire Teresa's attorneys. Teresa told my mom that I needed to get an attorney and she's threatening me, and here we are. And I have had a hell of a time being with my kids. So I'm asking for clear, accurate orders so I can comply moving forward, and we can get back into business of being good parents, and hopefully we can co-parent one day. But I don't think that's gonna happen unless opposing counsel comes to terms with all of the psychiatric evaluations that I've been under, and they're all benign. These accusations I'm delusional, I'm schizophrenic and paranoid, they don't have any real evidence, and that needs to stop. We need to be friends again, and we need to focus on our kids, and I'm hopeful that this court can help get us there. I've played by the rules for the past year. I do not want to be here. I respect the court system, but this is hell. This is absolute hell. I don't know what. I've never been hit this hard before in my life, and I've been hit a lot. But this is terrible for me to not be able to tuck my kids in. It's been over a year since I've been able to do that, and for the first 4 years they were alive, I was doing it every night. I was feeding them dinner, giving them baths, was being a good dad. So anyway, Your Honor, hopefully we can move past this and focus on the kids, not fictitious stories about who they think dad is. Thank you.
Okay, thank you, Mr. Steele. That concludes our hearing here today. As I mentioned at the start of this hearing or very early on, there are some judges here that are very good at kind of just issuing rulings from the bench. They take in all the evidence and they're able to kind of process everything they see and let you know right on the spot what their thinking is and what they're planning to do. As I mentioned, my thought process is generally that I read the PRE report in these types of hearings. I then have the hearing, then I go back and reread the PRE report to help better understand the types of evidence that I have reviewed and I have heard at the hearing. So from your perspective, what that means is you'll get an order within a couple weeks. I know there's a fear that I'm going to take this stack of binders, I'm going to go behind that door, and about 8-9 months from now, you're going to be saying, didn't we have a hearing or something like that? I can assure you it's not something I do. It's not my practice. One of the advantages of coming from the civil world is I have a lot of experience writing, and it's just something I'm comfortable doing. You will get a written order. It will be clear. It will articulate what the parties are required to do and why the court found that those steps were necessary. Along those lines, please don't interpret any of the court's questions for either party as a leaning one way or the other by the court. For example, as I mentioned with the questions I had for Mr. Steele, those are things that I have to have that information so that the court can issue a ruling considering all the factors that the court is required to consider. And the court will go through all those factors, the court will explain its reasoning, and ultimately the court is going to be guided by the best interest of the children going forward. So Along those lines, I will note that your youngest child is only going to turn 3 in just over 2 months. That means, like it or not, your lives are going to be somehow connected in one form or another for about the next 16 plus years, since child support obligations continue until the youngest child turns 19 years old in Colorado. That means hopefully there will be opportunities going forward for where the parties may be in the same location, such as graduations, whatever religious ceremonies are important to you, things of that nature. And it's going to be important that both parents, and I say this with no suggestion that the court thinks that either side is going to do this. It's an advisement I give in all these cases. Even in the best of times, parents who are together and seem like nothing can bring them down, people still make comments and offhand remarks. I would discourage you from making those kinds of remarks about the other party. One, it makes things more difficult in trying to manage your day-to-day life if you're telling the child something negative about the other parent, but it's not really healthy for the child or the children to hear those things. So I would encourage you, whatever animosity you may have towards one another, that you not share that with the children, so that they can grow up with each of their parents and learn from them how to be adults who treat other people with respect and dignity, which will inform how they treat other people as they grow up. I will ask the parties to each take their binders from the witness stand. I will keep the binders that you've given me here today. The court doesn't retain copies of exhibits, so when I issue my ruling, I'll give the parties 14 days to make arrangements to pick up their exhibit binders. If you don't do that, make those arrangements within the 14 days, then the contents of the binders go in the shredder and the binders go in a closet somewhere and you'll never see them again. It looks like petitioner has e-filed all of her exhibits from looking at the file. Respondent will need to e-file his exhibits downstairs in the clerk's office. You could do that by creating a cover sheet that just says, has the caption and says exhibits, and they'll take that and they'll process those for you downstairs. But it's necessary so that those documents are available should there be any review, whether it be through Rule 59, Rule 60 motion, or a appeal down the road. With that in mind, as I said, I will get this order out to you probably within about 2 weeks. That's been my general practice, and that's about how long it's been taking me of late to get them done, anywhere from a week to 2 weeks. There are difficult issues in this case, but this is not the most complicated case in the sense that there are 2 witnesses. There's not property divided in a divorce. The court finds that the issues are going to be relatively straightforward. For now, the parties are to continue any restrictions that are in place, as well as any temporary orders that are in place. And then the court will provide guidance in its written order once that gets issued. Ms. Winter, I don't know that it came up. It's probably in a document somewhere, but I want to make sure I didn't miss it. I assume that if there's child support order that Ms. Clark would like that to be paid through the Family Support Registry.
Yes, and there's already that order in place.
Okay, just wanted to make sure. Is there anything else that we need to address from the petitioner at this point?
I just had one question. Would the court like us to send you editable versions of our proposed parenting plans?
No, and there's a couple of reasons for that. Is I will read them, and they often provide good guidelines for me to look at to understand each party's position regarding what they want for a parenting plan. But I find that cutting and pasting or editing somebody else's document is the road to typos and saying things that maybe you didn't mean to say. So I will type that out from scratch. I appreciate the offer, but it's not something that I would use. So I'd rather parties not spend time or incur expense doing that. Anything else, Ms. Winter?
Nothing on our end.
Mr. Steele, anything further?
No, Your Honor. Thank you.
Okay. Thank you, Mr. Steele. You did a very good job, even though I know you're not represented by counsel in presenting. I understand what your positions are. I appreciate the thoughtfulness, whether or not you use ChatGPT. I understood where you were coming from. I appreciate your thoughtfulness in the approach. Ms. Winter, I know this has not been an easy case from your perspective. At least for the time being, to the extent any motions get filed, I will let you know if a response is going to be ordered by the court. And I'll let you know when and if that's going to change. Once the case is closed and it gets switched to magistrate, I don't really have the ability to kind of guide that process anymore. But I will let you know what the court's thinking is on that when it happens. And as difficult as it's been, I appreciate your professionalism throughout this process. And I know you've put a lot of hard work into this as well. So the court will stay in recess. Have a good rest of your day. Good luck as you go forward.
Thank you, Your Honor.
Thank
Thank
you.
you.